This is all on tape. Please stop.
Get out of the car.
Please don't hurt me. Why
Get out.
this? No, sir.
Welcome back to Advocacy Alchemy with Professor Ross. Today we have a good one, guys. This case takes us to Collegedale, Tennessee. Let's go back to March 10th, 2022. A DoorDash driver, Delane Emeri Gordon, gets pulled over for allegedly going 49 in a 35. What follows is a tangled exchange of rights, refusals, requests for a supervisor, and ultimately an officer's decision to deploy a taser. I'll tell you up front, this isn't the most egregious case we've ever seen. No one lost their life, but it's one of those close calls that could have gone much, much worse. This is one of the very first body cam incidents that made me want to create this channel in the first place. It raises some key questions. What's the legal limit of compliance during a stop? Is asking for a supervisor a protected right? Or does it come second to obeying lawful orders? And at what point does communication breakdown escalate into a constitutional crisis? We're going to walk through the footage, analyze the charges, they were all dropped later, and examine how this went from a routine speeding stop to a national conversation on policing, compliance, and the use of force. And as always, we have to bring it back to our guiding principle. How do you make it home safe? With that, let's jump in.
What's going on, man?
Hey, how you doing?
Pretty good. I'm Marshall just from Collegedale Police Department. Reading stops whenever you were coming down Talent Road. I got you at 49 and 35.
You sure?
Yes, sir. Do what?
I was asking, are you sure about that? Because I was going below that.
So what I got you at was 49. You got your driver's license, your insurance card, and your registration on you?
Do you have proof that you got me going after?
I got you by radar, man.
Am I allowed to see? Because
No, we're not doing that right now. If you want to argue all that, you have to go to court for it.
I'm saying that I wasn't going that fast.
But I'm saying that you are. So I need your information, please.
Why is it that I can't see proof?
Because it's in my car and you're not getting in my car.
I don't have to get in the car to see it.
I need your information.
Could you get your supervisor so that we can have
Give
proof?
me your information or you're going to be coming out of this vehicle.
I can get out, sir, but
Give me your information.
I'm going to turn my video on. Wow.
Get out of the car.
You can't do that for a traffic stop, sir.
623, start me now. Get out of the car, man.
Please don't touch me, sir.
I'm telling you to get out of the car.
All right, bro, let me turn my video on.
I'm going to tase you. Get the hell out of the car.
Sir, this is a traffic stop. Please don't hurt me, sir. I'm a good kid. Stop.
Get out of the vehicle.
I'm recording you. This is a traffic stop.
I will tase you. Get out.
Traffic stop.
Get out. You will be tased. Get out.
He said he pulled me over for a traffic
Get
stop.
out.
And tase me. You can't do that, officer, because I called for your
Get out.
supervisor. I have
Get out.
What is the
You
reason?
refuse to give your information. I told you to get out of the car. Now you're resisting. Get out.
I asked to speak to your supervisor.
Get out.
Sir,
Get out.
Please get your supervisor.
I don't give a shit what you feel like. I said get out.
Please stop it. Why are you being like this? This is how y'all really are? Please stop. This is all on tape. Please stop.
Get out of the car.
Please don't hurt me. Why
Get
you
out.
doing this? No, sir.
I'm telling you, get out.
I'm telling you that this is not lawful. Oh my God.
Get out.
That's not lawful.
Get
sir.
out.
That's not lawful.
Get out. Get on the ground.
That's not lawful.
Get on the ground and you can taste again.
Okay, but I have my life.
Get on the ground.
That's not lawful.
Get on the ground.
That was not a lawful.
Get on the ground.
Please help.
Get on the ground.
Please help.
Get on the ground.
I'm on the ground, but that's not lawful, sir. I have my license on.
Put your hands behind your back.
Please stop. Help. Please. Please help me. Please help me, Lord. This is not right, sir. I had a right to ask for a supervisor because you... That's not right, sir. I have my license in my hand.
Stand up.
Please help. I can get up, sir, but you don't have to do all this. Why? Why do you have to do this? I just don't understand. I'm a real good person. I'm delivering a DoorDash that goes right there. That was unnecessary.
You're right, it was necessary.
No, it wasn't, sir.
I told you to give me information, you refused to comply.
I didn't refuse.
Yes, you did.
No, I asked a question. I am allowed to ask you.
I need help. Good, thank you, sir.
That wasn't right. That was not right, sir. I'm delivering a DoorDash. I'm good. I'm a good person. You can't pull me out of a traffic stop, sir. I never refused. That wasn't right.
I have no radio signal. Let them know. Taser deployed and one in custody.
That wasn't right. That was so wrong. Like, what happened to you today? That wasn't right.
I'm not going to sit here and argue with you.
There's no
I told you to give me your information. You didn't want to comply. Then I tell you to get out of the car, and then you don't want to get out of the car.
I have my license in my hand.
They should be sending somebody.
I asked for the supervisor, ma'am. And you tased me because I asked for you.
Because you refused to comply, they were resisting arrest. I asked for your information.
You're scary. You pulled me out the car. I asked for help. My information was in my hand.
And you were refusing to give it.
I did not refuse.
Yes, you did.
I asked for your supervisor. I asked for your supervisor. Why am I not allowed to ask that?
Because we're not doing that. When I give you a lawful order, you have to follow it.
You have to abide by my request. I do
not have to abide by your request.
It's a request. I don't feel comfortable.
We're in the middle of a stop, and I'm telling you, give me information.
In the middle of the road.
This is where you stopped.
I could have kept going, but I don't know where to stop. That was so wrong, and you tased me. I've never got in trouble.
Thank you for stopping.
I've never done nothing.
Thank you.
That was so wrong, sir. I've never been tased, never been treated like this. I'm delivering a DoorDash, and I was not speeding.
You're fine, sir.
I was wrong. What's the problem? He pulled me over for a traffic stop. I asked, could I see the speedometer? He said, no, I'm not allowed to let you into my car. I said, that's fine. I don't feel comfortable, man. I have a supervisor. He yanked me. He pulled first of all, he opened my door without my consent, pulled me out of my car, tased me while I'm in the car, and said I'm not abiding by his request. I have my license in my hand. I just asked for a supervisor, and he got upset. That wasn't right to be tased and treated like that. You didn't have to yank me on the ground, or tase. You
didn't have to not follow orders.
I did not follow your orders. I asked to speak for a supervisor.
Because I wanted to see the radar.
Because I didn't feel comfortable. We stopped in the middle of the road, and no, I didn't feel.
Were you speeding?
No, sir, I wasn't. That's what I told him. I don't believe I was speeding.
Well, now you got bigger problems.
That's not a problem.
Where is he taking?
I was incorrectly.
He was on that side.
I told you he was going 607.
He tased me while I'm in my car for a traffic stop. You can't do that. You can't pull me out.
It's not why you were tased.
You can't treat me like that. I asked for your supervisor, and you went crazy. Like, that wasn't fair to me. That wasn't fair to me at all.
You gonna grab that side?
You can't do that during a traffic stop. You can't do that during a traffic stop, sir.
There's one probe in the side. I don't see the other one.
Are any of you all his supervisor?
Yes, sir, we are. We'll talk to you here in just a minute. Let's get this thing cleared up.
I got one thing too. That was ridiculous.
I know what else.
I don't see it. Oh, right here.
You never had to do a tase. I'm a good person.
You up, though? Just drop it. Drop it.
I told him I wasn't speeding. I'm on my way to do a door back there that's a half a mile up.
You got exactly in all this stuff? You already been running all this?
I'm not running.
Excuse me. As far as what I repeatedly
hold on.
talk about.
Before you start, you have the right to remain silent. Anything you say can with you is for the law. You have the right to an attorney. You can't afford one, won't be appointed for you. You understand those rights? You want to continue talking to us?
I'm not under arrest.
You're not. That you're right. So, right? You want to continue talking?
I would like to. I would like to speak to the supervisor that I requested.
You got a few of them out here. I'm ready to
Can I take my sunglasses? Can you take my sunglasses off? You have no right to tase during the traffic stop. You have no right to pull me out of my car. I did not deny any request. I had a request.
What was your request?
I asked to speak to the supervisor. That's specifically all I asked, and that's all I wanted.
Well, you don't have one. So you asked for a supervisor. You don't have one.
He yanked me out of my car. Like specifically was yanking me out of my car. I said, no sir, I don't feel comfortable. I just want your supervisor. Like, it shouldn't have been that hard. From what I've learned, I should be able to request that, and that be it. I speak with the supervisor for whatever circumstances the supervisor says I can understand.
So what all going on? What all going on?
So I saw him for $49.35. Kept asking for his information. Well, I want to see your record. Well, I'm not seeing that. If you want to do all that, you can go to court. No, you didn't stop me for that. And so I tell him to get out of the vehicle. No, I'm not getting out of my car. Then he's like, I want to see your supervisor when I grab hold of him. And so I gave him multiple times to get out of the car. Wouldn't do it. This is even after going hands-on. Pulled my taser and gave him multiple warnings. You're going to be tased, you don't get out of the car. He still don't get out of the car, so that's when I popped him.
You good? Did you fall and hit his head or nothing like that?
No, he was still in the seat whenever he got tased.
I just need to check him just for the taser deployment.
I kept trying to get him out hands-on, and he wouldn't get out. And transitioned to taser. And told him, you get out of the car, you're going to be tased. Multiple times. When he still didn't get out, popped him. And that's when he finally started complying.
Yes, ma'am.
Yes, sir. No, just skinned up.
You stopped him for
49.35. He was refusing to follow any commands, refused to give his information, refused to get out of the car. And so,
Do what? Oh, they want tags?
there was some old man who stopped. I didn't get his name.
I get your car.
I got another one in the car. Do what?
You good?
My knee messed up, but it's fine.
Well,
Do what?
you ain't stabbed, so that's good. Lord, I say never cuss word. I'd get out of my mouth. Kicking the dash. I'm like,
Get here and then check him out. Just take him up further to the station and just go ahead and start doing the booking paperwork on him.
Okay, let's take a moment and break it all down, okay? So the stop begins with Officer Evan Driscoll. He tells Mr. Gordon he's clocked him at 49 and a 35. We said that at the very beginning, you saw it. Gordon is calm, but he's a little bit confused. He questions the reading and asks to see the radar. The officer refuses and says this is an issue for court. From there, Gordon requests a supervisor, and this is a right that many people believe they have during a traffic stop. But from here, everything goes off the rails. The officer demands Gordon exit the vehicle. Gordon doesn't. Instead, he continues to ask questions and record on his phone. The officer opens the door, and before you know it, he shoots him with the taser. There was no physical aggression from Gordon, no threats, no sudden movements, just confusion, resistance, and a sincere desire to speak with a supervisor before following order. The critical legal moment here, Gordon doesn't physically resist, he simply delays compliance. And while it's true the officer gave repeated commands, the escalation to force came swiftly, without any apparent danger or active threat. That's where this crosses the line into some of that questionable territory. Let's break down the law. All right, so remember this happened in Tennessee. There were about 3 charges that we see that are very clear here. All right, so first you have speeding, second, resisting arrest, and third, failure to comply with lawful orders. All right, speeding is found under Tennessee Code Section 55-8-152. And it's simply exceeding the posted speed limits is a Class C misdemeanor. Here, Gordon allegedly was going 49 and a 35. Now, what's the penalty? That's only 30 days in jail and a fine of $50. In most cases, that's handled just by a ticket and not a takedown. Number 2, resisting arrest. This is found at Tennessee Code Section 39-16-602. It makes it illegal to prevent a known officer from effecting an arrest or stop by force. Notice the word force. Was there any force from Gordon here? He didn't strike or push. He sat, he recorded, he asked for clarification. This charge will only be allowed to stand if the court agrees that sitting still and asking for a supervisor constitutes obstruction by force. Number 3, failure to comply with lawful orders. This is found under Tennessee Code Section 55-8-104. And it is the willful refusal to comply with a lawful directive. Something as simple as exit the vehicle. Gordon's delay arguably falls under the statute, though the major debate lies in whether his request for oversight voids or mitigates the refusal. Let's talk about the outcome from all this. All right, all charges were dropped by the district attorney. Internally, the police department cleared the patrolman, but civil suits and a federal review followed. And all that really matters. Next, let's move into the evidentiary standard. Now, if you're new, we talk about the evidentiary standards every day. There's 6 levels that we talk about, and these are major 6 standards in American law. All right, we go from almost the non-existent to beyond a reasonable doubt. So let's start with number 1, mere suspicion. Mere suspicion means a hunch, but it's not enough to act on. Okay, that's simply that gut feeling somebody gets that something's wrong, but you don't have any evidence yet. A good example here, the officer sees a car and feels the driver looks nervous. That's not enough to pull somebody over or anything like that. Number 2, reasonable suspicion. All right, this is defined as when an officer has specific facts that suggest that a person may be involved in criminal activity. The legal lease is that criminal activity is afoot. Here, the speeding radar's reading provides reasonable suspicion for a stop. Number 3, probable cause. All right, this is defined as being more likely than not that a crime has occurred. If the officer had video or a radar showing speeding, that would establish probable cause for a citation, but not necessarily an arrest here. Because remember, if we're talking about speeding, usually that's handled with a ticket. Number 4, preponderance of the evidence. All right, this means that more than 50% likely something happened. This is used in civil trials. This will come into play if Mr. Gordon sues in federal court for excessive force, which I believe they have already done. Number 5, clear and convincing evidence. This is highly probable, but not absolute. This is also used in civil cases, and it requires approximately 75% of the evidence needs to point to one side claim being true. And that's where you have that high probability and that high likelihood of success. This is used in custody cases. This is used in fraud cases. This is used in employment cases where you require more evidence to prove your point. If the officer was disciplined, this is the standard that may be used for an administrative hearing. Number 6, beyond a reasonable doubt. This is the standard for criminal convictions. This is the highest standard in American law. In Gordon's case, this bar wasn't met for any charges. Hence, the charges were dropped. Let's move into the jury perspective. All right, now, if we're going to talk about being on a jury, there's 2 different scenarios we can have here. All right, scenario number 1, if the charges stood. So we're here on those 3 charges we talked about above. Would you convict Gordon of resisting arrest or failure to comply? Would you say sitting and recording while repeatedly asking for a supervisor rises to resisting? Would you consider Gordon's delay to be willful defiance or a misunderstanding of what his rights are? What evidence would convince you beyond a reasonable doubt that this man deserved to be charged? All right, let's move into the second scenario that's possible. Now, the second scenario is a civil lawsuit against the city and this officer. So now we're talking about Gordon filing against them. And the claim would probably be excessive force. Now, if that's the situation, would you believe the officer was justified in using the taser in this situation? Was there any immediate threat or danger to that officer? And number 3, was there any other way to resolve this situation? Now, if you're thinking like a juror here, remember, in a civil case, the burden of proof is only preponderance of the evidence, which means only 50% of the evidence needs to point to Mr. Gordon's claim being true. Would you find it more likely than not that the officer went too far? Let me know in the comments. Now, let's view this situation realistically, okay? This wasn't a worst case scenario situation. Now, it could have been. I can point to several mistakes that Mr. Gordon made. He failed to comply with commands. He thought recording and asking for a supervisor would protect him. But the law doesn't always give you the shield in that moment. That said, Officer Driscoll's response escalated quickly, and that decision is still under scrutiny. The use of the taser for a non-violent driver who was asking for clarification, that's not going to sit right with a bunch of people. And that's for a good reason. This is a prime example of why we say, make it home. You can fight the legal battle some other time, but you can't undo what happens on the street. The street is not the place to argue your case. Make it home, go fight those battles in court, or hire somebody to fight those battles for you. So let me hear from you. Should Gordon have complied sooner? Should the officer have de-escalated? And how would you rule both criminally and civilly on this case if you're on the jury? Comment below, make sure to like, subscribe, and share this with someone. With that, everyone make it home safe. Remember, this is Advocacy Alchemy. I am Professor Ross, and I'll see you tomorrow. Everyone have a good day.